going to be chill with this, okay? We're going to be calm with it. I want this to be connective. What are we doing in these workshops, these 5 workshops we're going to do? We're building fundamental skills. So they're going to come off kind of amateur, okay? They're not into the nuts and bolts of everything yet, right? We're not going into a ton of practice and the hands-on stuff that we're going to be doing during your general courses, depending on when you are taking the bar, okay? So with that being said, let's get into our legal analysis, IRACing, writing, fundamental skills building. Some of you that have been in early bar prep for a couple months or so already know a lot of this stuff already, so it'll be a good refresher for you, okay? And then I will prompt for times for questions, take notes. What do I want to see as well? I want to see that what I'm teaching you today and in the subsequent workshops will be implemented and applied to your early bar preparation practice. Okay. That's also what I want to be seeing. So let's get started. It's nice to see everyone's faces. And, going into February, that will be my 31st bar exam in a row that I will be hosting. And I've tutored probably over 4,500 applicants at this point. So it's so crazy to have and a very big blessing and a lot of gratitude. So thank you for trusting me with your journeys. I'm just getting to know a lot of you. Dawn, I met in my office was it last week or 2 weeks ago, and got to know you very well. And I'll be getting to know everyone here. The bar exam in California gets a very big bad rap. It's not as scary as you think, okay? There's a lot of work to be done. There's a lot of skills to be done. Bringing it back to just before I get into the workshop, the fundamentals of writing, the fundamentals of taking multiple choice questions, it's not really taught, right? So for the most part, we go from a lot of law, right, from law school or from learning law and bar courses, right to what? Practice. We don't build those fundamental skills. It's almost like applicants are assumed to have them before they get into bar preparation, right? If anyone's taken the bar here before, there's like an assumption you know how to issue spot well, you know how to give a legal analysis, you know how to do all this in timed conditions. That is a misconception, right? I mean, we need to develop and redevelop these consistently. So let's get into this. Is going to be, again, a very chill lecture on your blueprint for California bar exam essay writing. Okay? You're all excited? Pumped? Let's do this. All right. I have my coffee. Sergio, I see you have yours. I don't know. I always will have one of these. Get used to it every class. Usually I'll only get to like the middle way, but it's what keeps me going. All right. So we have a little document here. You all have this in your materials, but you don't need to have materials today. Just follow along with me and connect. So what do you do when you get to a bar exam essay? It will look something like this. Mm-mm-mm. All right. This is February 2007. Everyone can see the sharing screen correctly? Oh, good. Okay, thanks. So this is a prompt. You have your facts and then you have your calls of question. So this is what every California bar exam essay will look like. What will vary is the length of the facts, and you will see a variation of that, okay? You also will see sometimes 2 calls of question, sometimes 4, sometimes 3. It varies in the different subjects. Sometimes even just one, right? So, like in contracts, you could just have the breach of contract with any applicable remedies. You, in my course, are going to be exposed to so much practice that by the time you hit your exam, it would be a major anomaly to not have seen a version of that essay before. Okay. So don't worry so much about this right now. Remember, this is the basics. Okay. So I know the wandering mind. Remember, I was a bar applicant once before, and we start thinking, wait, how many different variations? What about crossover essays? What about, how these areas are tested? I got you covered, okay? We're going to go through all of it. It's a journey here, and it is definitely a process. But for purposes of today, I want you to start always with your calls of question when you get to an essay. Now, of course, in your practice right now, you know what subject you're in. So you already know kind of what to expect. But you don't know what category I'm giving you on your essays, right? So what you really want to try and see is, do I have a specific or a general call of question? That's number one. And so what is the difference? Excuse me. Let's look at these calls. Can the jury properly find Dan guilty of first degree murder? Somebody tell me, and there is a raise of hand function. If you see it, if not, it's okay. Just unmute yourself and blurt it out. I don't care. Is that a general or a specific call? Can the jury properly find Dan guilty of first degree murder? What do you think? General or specific? Olga.
I think it's specific for
Great.
first degree murder.
Right. So it's giving us a specific category within criminal law that we know the elements for. But actually, it's kind of tricky. And I know a lot of you have maybe even not reviewed criminal law yet, or maybe you've reviewed it months ago. First degree murder actually has two parts. There's first degree murder in terms of that lying in wait premeditation. And I'm not teaching criminal law right now. This is just an example for specific versus general. It also has first degree felony murder, right? So, yes, Olga, you are correct. This is kind of a specific call, but specific on its face means there's no question as to what they're asking. If there's a subpart in that category, it's still kind of general. You understand where I'm going with that? So here it's first degree murder, but you will have to decipher whether the initial intent of the defendant was to carry out an inherently dangerous felony and then a killing occurred. That'll be felony murder. Or it was a direct premeditation. Okay. And then you'll be in that first degree premeditation killing. So second degree is the same in call two. Second degree can be voluntary, involuntary, or common law, you will learn. So even though it is kind of specific, it's kind of tricky. You will get good at issue spotting. The more that we learn the approaches, the more that we do our practice. What I'm getting at is I want you to first go to the calls of question to try and at least get as close as possible to the category that they are testing. Okay, that's number one. Now, if it is a general call, we don't really have any pure general calls here. A general call would look like in criminal law, what crimes, if any, can Dan be convicted of? You see how that is so general? It's very broad, and there's approach for all this that you will learn when you go through the approaches and the lectures. But for purposes of today, in your practice right now, I want you to start always with the calls of question, because it does make a difference if you get a very specific call, how you then attack the facts, right? So you will learn, for instance, that first degree murder requires a specific intent, premeditation, and deliberation, right? That's that general first degree murder. When you're going through the facts, and you'll see, and we'll read these facts in a little bit, that there's no inherently dangerous felony being occurred, right? There's none carried out. So it's just that pure premeditation. Once you learn the approaches, you won't even need to issue spot. You already know what your issues are once you figure that out. But my point is, it'll make a big difference the more specific calls you have. General, not as much. My point is, try and get a feel for the area of law that you're in and any subcategories. That is our first step of approach. Back to our document here. So, excuse me. All right. So read the calls of the question below to determine the subjects being tested and whether or not you have a general or specific call. Read the facts and circle party names, spot issues per sentence, and start mentally putting together the roadmap for organizing your essay. Now, that is, in general, what your essay approaches and your miscellaneous topics will be walking you through. How to approach every different type of categorical area. Now, once you I would read the facts once to get a feel, okay? You don't really need to read them more than once. And then you will start issue spotting, okay? So you issue spot per the calls of question. And that should take about 10 minutes. Now, that is not, excuse me, in your initial early bar prep practice. Right now, you're issue spotting open book about 30 minutes to 45 minutes. Okay. So this is ideally on the exam. Nobody is ready for closed book writing yet. So, in the scheme of timed writing and practice, let's say there's like 5 steps to writing a California bar essay and training on it. Timing is step 4. Every early bar prep applicant, from the inception of their schedule till the actual general course, will not exceed step 3. Okay? So, step 1 is learning law and approach, or 2 is kind of learning the approach, then doing the practice, and then assessment with me. I will let you know on an individual level when you are ready for that time practice. So, what happens in early bar prep a lot is applicants start challenging themselves, closing the materials. The guidance is to write open book. You are a researcher right now, okay? You are learning the steps on the how to, on the strategy. You must do that with the materials in front of you. And you'll be surprised that even with the materials in front of you, not all applicants get what I'm having them do. Okay. So it's really important that the navigation of approach and the literal taking, and I'll go through approach in a moment, is being implemented in your early bar preparation writing. I will know if you're not following that, and that's only going to hurt your training right now. Okay. So trust the process, even if it feels like, gosh, I kind of feel like I'm cheating right now. I feel like, I have the materials in front of me. Like I won't have this on the exam. There's a method to my madness that I've been doing for almost 16 years, and it works. But it will feel a little bit kind of uncomfortable, okay, doing it open book, but there's a reason I have you do that. All right. So you're going to go to the call. I like to repeat a lot. Make sure you see, get to know the categories as best as possible. If you're not sure, go to the facts. Then you read through the facts 1 to 2 times max. And you will, as you get very skilled on issue spotting, it's not going to happen right away for most. You'll start seeing the issues pop out more and more. I want to actually say something. I have a lot when I talk. So get ready. I have a lot of info in here. When you are doing practice, keep in mind the first time you do your first negligence essay, you can totally miss all the special duties, right? The second time you do a negligence essay, then you're like missing the vicarious liability. It may take you literally 7 to 10 negligence essays, not torts essays, right? Torts is humongous. And negligence does, I'm giving negligence as the example, it crosses over with a lot of different areas of torts to really be ready to issue spot for negligence. Keep that in mind. There's so much misconception when it comes to California bar exam prep. Oh, I did one negligence essay. I'm ready to rock and roll. I'm going to get my 65, 70. That's usually not the case. Okay. Why? There is a lot of variation on the way that they test these areas. So be patient, okay, with yourselves and realize you may have a day where you're issue spotting and you're getting all your issues, and then you may have another day where the issue spotting drops. Okay. So in your early bar prep, you're going to be issue spotting 30 to 45 minutes open book. If it takes you longer, I'm okay with that. Your goal is to navigate the approach, to sit with it, to learn what is relevant and what is not. So before we get into how to issue spot, let's look at an approach together. So this is a variation of the homicide approach. I just revised this. I've been going through all the approaches, and I'll be releasing some updated ones soon, about 20 soon. Okay. Very excited. About December, I'll have those ready. I've been working a lot on those. And you get to an approach. This is just the preliminary stuff. And then I start teaching on the whiteboard. Okay. So you have a video for all the approaches that also have a document that support it. Now, for those that have already been working these approaches, I know some of you only got started this week, so you may be like, I haven't even seen this yet, okay? But you will. This is a big part of the program. Right now, I have about over 50 of these. So what is my goal with essay approach? Most courses do not have them. Why? I'm not really sure. The trajectory of most preparation is to go from the law, again, right to your practice. So there's no stopping in I learned homicide. Now, how do I write for the 7, 8 variations of it, right? We have to know that because what happens on essays on the bar? What do you want to get? 65 or higher on an essay is the ideal scoring range. Now, technically, you can actually get a little less than that, but not in my program because I'm pushing you to create buffer. Why would we settle for just the passing scaled mark, right? We want to push it. So ideally, 65 to 70 is your real range, okay, in your overall scoring. What is weighed the heaviest? What do you think? Anyone want to take a guess? Out of your essays, the IRAC, IRAC, which I'll talk about in a moment. What is weighed the heaviest? Donna.
Analysis.
So, good answer. Not really. Think about that because it is in some subjects, it's the issue. Because if you miss the issue, you never even get to the analysis for that issue, right? So, the analysis in some subjects are weighed more than others, and you'll learn that. But the issue spotting, missing of key issues, the headings, okay? So everyone write down, headings are synonymous with issues, okay? Now, you will see on California bar models, the state bar always releases model A and model B, 2 models to each essay. We have our own models for everything that you're going to be writing, okay? So you're going to go off of our models. But there are some essays that I don't have models for yet because you're going to be doing at least 100 essays, by the way, by the exam you're taking. So don't think it's all happening now. Early bar prep, very minimal practice. When we get to that 2.5 months, we're pounding practice every single day, okay? Now, when you issue spot, the issues are worth anywhere from 5 points in the entirety of your IRAC. I'll show you how this breaks down in a moment, to 25 points. So think about it. If you're in an essay like professional responsibility, ethics, lawyer ethics, which is one of the lowest scored essays that come back, you may only have 8 to 10 duties in a pure, what I mean when I say pure is no crossover. They're just testing professional responsibility. That subject you'll learn does cross over with numerous subjects, okay? But if it's just testing a pure PR, 8 to 10 duties. So if you miss 1 or 2, that could be right off the bat already at a 60 your essay or a 65 because each one could be worth 25, 30 points of major duties. Issue spotting is the number one most important thing to get points on a California bar exam essay. So these approaches were put together based on 25 years of the California bar exam. What they do is they walk you through when an area of law is tested, what your issues will always be. So there are some areas I can tell you, if you spot first degree premeditative murder, specific intent, premeditation, deliberation, those are your issues. Now you're going to consider defenses. And again, I'm not teaching criminal law right now. I'm just giving context. Okay. But you don't even really have to think that hard, right? Because those are your issues. But where it gets a little bit more murky is number one in a general call for sure, because you have to spot the the causes of action or the procedures or the evidentiary issues or the duties on your own. I still give you a blueprint to navigate how those issues are typically tested, okay? But, and another way is if you have, like we saw before, where it's a specific call, but it can kind of go either way, okay? You will get to know how to navigate the calls very well the more practice you do and the more approach you learn. What is my point? The approaches are the blueprints. They are the gold standard to your essays. I have applicants, and if you go on our Instagram, you will see just like you are all not going to be, you are amazing applicants that work so hard. I really think I have the hardest working applicants. They literally make the approaches on poster boards. They post them on their ceilings in their bedrooms. Now, I'm not saying you have to do that, but it's not about just, this is very important. It's not about just watching an approach one time. That's not going to cut it. You sometimes, especially if it's an area of law that maybe you struggle with, You want to watch it two, three, four times, study it. Inevitably, you want to be able to get in front of a whiteboard and teach your friend or your child or your whoever it is, your colleague, the approach on the whiteboard. Okay? Not right now, not during early bar prep, but my point is you have to take them literally, connect with them.